university campuses are situated are in the traditional territories of diverse indigenous groups, and we acknowledge with respect the histories and culture of Beothuk, Mimak, Innu, and Inuit of this province. We encourage everyone to reflect on the lands where we are located and the indigenous people for whom these lands are traditional territory. Thank you. And for the in this presentation information session, first, we are going to have a presentation from Meg Carrot. Sorry if I pronounce your name incorrect. I'm really sorry about that.
No worries.
And after that, we would take the questions from our students, and we will try to answer all the questions and queries related to your tenancy and off-campus housing. All these questions. Thank you so much, Mr. Garrett. Can you please share your slide? I am just stopping your main slide.
Here we go.
Thank you.
Make sure it's the correct one because I've got two open there. Oh, sharing my presenter view, isn't it? One second there. It's not letting me just share the presentation. There we go. All right, everybody can see my screen there fine? All right, so thanks everybody. Welcome to our information session on housing law from the Public Legal Information Association of Newfoundland and Labrador. Just a quick outline, we'll talk a little bit about ourselves. I'll try to be brief on that. We'll talk a little bit about housing law, some questions about residential tenancies, which is what you'll be worried about if you're renting houses in Newfoundland and Labrador or apartments. And we'll have some time there for any questions. Just a little bit about Plian. We're a organization that provides free legal information on your rights and how to access justice in Newfoundland and Labrador. We've got offices in St. John's and Happy Valley Goose Bay, and we cover a number of topics. So if you have any legal questions, or if you're not even sure if it's a legal question, feel free to give us a call. Our information is going to be at the end of the slides, so it's there, and we're available any day of the week, and you can email us after hours if you have any questions. So let's cover housing law. We're not going to be covering employment law on this one. It just outlines that that's another thing that we cover a lot of the times. But we're going to cover the responsibilities of landlords and tenants, how to access residential tenancies board, and how to file papers and requests. And those are some of the other things that we deal with, family law and immigration. If you need legal advice, legal questions, you can call us. info@publiclegalinfo.ca is our email address. So if you want to email anything after hours, feel free, and those are our numbers there. So let's get into housing rights. There are kind of three main things that we talk about. One is the landlord-tenant relationship. The second is paying rent and rentals due, and then questions of damages and repair. In Newfoundland and Labrador, the piece of legislation that governs everything is called the Residential Tenancies Act. So this is a piece of legislation that covers any residential tenancy in the province of Newfoundland and Labrador and governs the basic requirements. You can't opt out of the Residential Tenancies Act. The act supersedes anything that may be conflicting in a contract that you have. So the Residential Tenancies Act covers everything. A tenant, so to define that, is you likely as students coming here are likely going to be tenants. So if you're paying someone else to live in a house or an apartment, you're the tenant. If you're renting out your home to somebody else, if you're lucky enough to own a property here in St. John's and you're able to rent it out, or if you're you have a larger home and you sublet it, then you would be a landlord. So you're the person who is providing the housing. The act doesn't cover a few things, though. It doesn't cover hospitals, tourist inns like bed and breakfast, prisons, temporary shelters, nursing homes, university residences, cooperative housing, which is a form of housing where you and a number of other people buy into the house or the area of houses. Not a very common thing in Newfoundland and Labrador, much more common in other provinces, but we do have a couple of cooperative housing units here, and they don't include boarding houses. So if you're not renting a normal way in either a week-to-week, month-to-month, or year-to-year rental for your tenancy, it may be one of these other things. So if you have any questions about whether or not the Landlord Tenant Act or the Residential Tenancies Act applies to you, feel free to give us a call. Most everything when you're renting a space to live in, though, is going to be a residential tenancy, and the act's going to apply there. Before you moved in, we talked about this a little bit last time, but definitely you'll want to make sure, is there any damages? You'll want some kind of report and some information on everything in the apartment or the house that you're renting. Take pictures of everything, take pictures of the floor, take pictures of the wall, take pictures of anything that you notice that might be out of the ordinary, bumps, scratches, anything like that, just so that you have documentation of what the place looked like when you came in and what the place looks like when you leave. That way, you're going to protect yourself from any disputes with the landlord over whether or not the damage was there when you moved in. Very normal to see wear and tear in a house or an apartment that you rent from. Just document it so that you're not finding yourself responsible for it at the end of the day. When we talk about rental agreements, we're looking at a written, verbal, or implied agreement. So, written is obviously going to be the best one, and we at Pliant definitely recommend get everything written down that you can. It's going to protect you from things in the long run. If someone tells you that you're going to be able to use a parking space, get them to write it down. If someone tells you that you're going to have access to a washer and dryer, get them to write it down. Stuff like this is very important and can affect your rental in the long run if you don't have it written down on paper. Verbal agreements and implied agreements are I don't want to say uncommon necessarily. In Newfoundland and Labrador, there is a very large tradition of informal renting through verbal and implied agreements. But I would caution you to consider the options before going down that route because it can create more headaches in the long run. When we're looking at rental agreements, they can either be week to week, month to month, or a fixed 6 to 12 month term. We'll talk a little bit about what the differences are for those later, but ultimately the big distinguishing feature of them is how much notice and how much time needs to be given either to a tenant or a landlord for the tenant to move out or for the landlord to evict. All right. So our rental agreement, what we're going to be looking for in it is the rental amount and the security deposit amount to make sure that we know how much rent we're paying and how much a security or damage deposit is going to be. We're going to want to know who's going to be living in the apartment. So if you have a rental agreement and you're going to have roommates, make sure that their names are either on the rental agreement or they have a separate rental agreement themselves. You want to make sure anyone who's living in the apartment knows the rules and everyone's on the same page. Ask if utilities, cable, and internet are included. We talked a little bit last time about how you may see utilities included in a rental agreement or in a listing. Often, what they mean by utilities included is just power or power and heat. Cable and internet and phone are not commonly included in rental agreements in Newfoundland and Labrador, but you'll find places. So just make sure if any of that is included, that it's spelled out. You might often see POU in a listing for a house. What that means is pay own utilities. You, as the user of the utilities, will have to pay for the cost of that utility. It depends on the landlord. Some landlords will have you set up with the power company to pay them directly. Some landlords may send you the monthly power cost and tell you, here's your utility cost for the month. With cable and internet and home phone and stuff like that, usually you're going to have to go out and do that yourself and contact one of the local providers, Rogers, Bell, Tech Savvy. There's a number of smaller independent ones as well to come and do the hookup in your house or apartment. And there may be some hookup fees involved with that. So just keep that all in mind when you're renting, that there can be these kind of little hidden fees there that if they're not explicitly outlined in the rental agreement, you're going to be responsible for them if you want them. Smoking versus non-smoking. I'd be very surprised if you find rental agreements where someone allows you to smoke in a home if it's not a home that they're living in and that they've smoked in before. The tides have definitely turned on that. So if you're a smoker, keep that in mind. There may be some other conditions. I know I've seen rental agreements where the landlord has said that there's no smoking on the property, and that's their choice to put that in the rental agreement, and it's your obligation to comply if you agree to that in the contract. Could be other things such as defining what's a shared community space if you're living in a home. They could talk about the living room and kitchen and bathrooms as shared living spaces. It could talk about the use of the backyard, a use of a shed, whether or not there's going to be snow clearing included in the winter. A number of these things come up, and there's something to think about when you're renting, that there may be these little bonuses, or there may be these little things that you have to kind of consider before you want to rent, whether or not you're willing to take on the extra cost of snow clearing a large driveway, or if there's stairs that you're going to have to salt and maintain throughout the year. So number of things can be included in there. Generally, the more stuff that you get spelled out and the more stuff included in your contract, the better off you'll be. If anyone has any questions, by the way, feel free to jump in and let me know. Chat's kind of off to the side there for me, so if one of the lovely hosts could let me know if there's any questions, I will feel free to stop, and also feel free to tell me I'm talking too fast. The Newfoundlanders are incredibly fast-talking people, and I have a hard time myself slowing down sometimes. All right. So the damage and security deposit, you'll hear it called, one or the other, depending on who you're speaking to. It's kind of more American to call it a security deposit than a damage deposit, but both of them are the same concept. This is the money that you'll give to your landlord in case there's damage to the apartment. So you give them a portion of the rent, and you can see there on a week-to-week contract, it's 2 weeks rent. On a month-to-month contract, it's 3/4 a month's rent, and the same for a fixed term. So 6 to 12 month contract, it's 3/4 of a month's rent is what they're allowed to charge you. So you give them this money up front to guarantee that they have some money in case there is damage done to the house. The tenant has to be given a receipt. So when you give them the money, they have to give you a receipt in some form. It doesn't have to be like written up on proper receipt paper. If they acknowledge it through an email, that counts as a receipt as well. When the lease ends, the landlord has to return that security deposit to you within 10 days unless they file a claim to keep it. So very often what will happen is once you move out, the landlord will come in and see if there's any damage done to the property. They'll tell you what the damage to the property is, and often it says there that they file a claim to retain it. Now, we also advise, going down the route of negotiating and trying to seek alternative dispute resolution with your landlord. If you look and they provide evidence that it's damaged and you agreed, it's probably better to not make them file a claim at the end of the day if you want to keep a good relationship with that landlord and maybe rent into the future. So there is that requirement for them to file a claim to retain that money, but I think, let calmer heads prevail. And if you agree that you damaged something, then I wouldn't object to it. If they don't return it within that 10 days and don't file a claim, you get to file a claim in response to demand that money back through the landlord tenancy board. In paying rent, rental increases. So your rent when you move in will be your fixed rate of your rent for 6 months on a month to month or fixed lease, or 8 weeks on a week to week notice. Your landlord cannot increase that without notice, and they cannot do it within the first 12 months of an agreement. We've seen it, and it's not uncommon that landlords do try to increase the rent before that period. They're not allowed to do that. If a landlord tries to increase the rent during that period, you can file an objection to the board and enter into that objection why you're not paying the rent. So you would not pay the rent, you would file your objection to the board stating that they're trying to make an illegal increase to the amount of rental costs for your property, and because of that, you've not paid the rent. And then once that decision is handled at the landlord tenancy board, then you will go on to pay the cost of that rent that you properly should. If you don't pay your rent in Newfoundland and Labrador, you could be charged a fee for late payments. It should be spelled out in the contract. As well, a termination notice may be given to you if rent is 5 days late. So at that point, if you're 5 days late and we say here clear days, those mean, no holidays in the middle, no days where the landlord was unavailable or otherwise unable to be contacted, or days that, you were unable to actually do it. It has to be 5 real days that you have an opportunity to pay your rent after the rent is due. If you fail to pay rent, the tenant, so you can be given 10 days notice that you have to move out. So you'll have to move out within 10 days of receiving that notice. And that's specifically for failure to pay rent. And that's one of the few cases where we'll deviate and have a really short period of time for an eviction notice for a landlord. I just want to jump back though. A landlord does have the opportunity to evict anyone for any reason in Newfoundland and Labrador. It's a little bit different than some other provinces and jurisdictions. A landlord on a month-to-month contract will have to give you 3 months notice of a eviction for no reason. So there's some special cases where they can evict shorter than 3 months, but that's the basis for the month-to-month and fixed eviction notice. So as a renter, you have some responsibilities. You have to pay the rent on time. You have to keep the living space clean and livable. So you want to make sure that nothing's growing, that you are not creating any pest issues or any buildup of any dirt or anything around the house. If you do damage something, repair it. It is your obligation. It's also important here to mention that folks should definitely look into getting tenant insurance. As someone who's living in someone else's house, you're not technically insured and your belongings are not technically insured by the homeowner's insurance policy. Some may include that, but it's not very likely to see that. Tenant insurance will protect you from any damage to your belongings that may be caused by something in the house, and they also protect you in the case that you or one of your friends or someone else who's living in the home damages the home unintentionally. You can then avail of your tenant insurance. You'll just want to make sure that when you look to get it, make sure to ask what the policy covers to make sure that all of the issues that might come up are covered. For example, I have a tenant who lives downstairs. He has a policy that covers up to $100,000 worth of damage to the property. I got a copy of that insurance agreement from him. So now I know as the landlord, if there is any damage caused to the property during the period of time that he's insured, rather than having to worry about going after him for the costs, I can go after his insurance. And as the tenant, it'll also protect you because you won't have to worry about the landlord coming after you personally. Your insurance will step in and defend that action and defend the costs of that for you. Make sure you're following the rules and terms of the lease. Like we said, you want to make sure that if there's common spaces, that you're availing of the common space and not taking them over for yourselves. Give proper notice. We'll talk a little bit about notice in a second there, especially the renter's responsibilities, the tenant's responsibilities when it comes to giving proper notice. The landlord has responsibilities as well. They have to provide you a copy of the rental agreement within 10 days and provide you a copy of the Landlord Tenant Act. That doesn't mean that they have to provide you with a physical copy, and I can't remember the last time I've seen anyone with a physical copy of the Landlord Tenancy Act. Generally, most people agree that, yeah, I agree. You sent me a copy of the legislation online. That's fine. Technically, under the legislation, they do have to provide you with a print copy, but in reality, it's one of those situations where most people don't want a physical copy of that, and it's easier for most people to find it online once they've been directed to it by their landlord. It's the landlord's responsibility to make sure that the property is in a good state of repairs and make repairs when needed. So if you cause any damage, it's your responsibility to make repairs. If the house in just the normal course of use takes damage, it's the landlord's responsibility. So in the case of plumbing failing, there being damaged electrical sockets or leaks in the roof, damage to parts of the flooring that start to sag over time and become dangerous. If there's anything like that that comes with the normal course of wear and tear and use in a house, that's the responsibility of the landlord to maintain. That's why you're paying them the rent money, is that money is supposed to go towards making repairs and making good on the home. The landlord also has to make sure it's safe and secure in the home. They have to make sure that, the building's not going to collapse around you, that the door has locks, that there are doors on the home, that third parties are not going to have access to the home, that it is your place. You have what's called peaceful enjoyment of it. That means that no one is interfering with your enjoyment and it's your space. Finally, they have to ensure that there's heat, water, and electricity running in the house. So if for whatever reason you're looking at a rental and you get there and it turns out there's no heat, water, or electricity, if any one of those are missing, you're no longer bound to that rental agreement because they aren't providing you with a livable space. So, things the landlord can do, they can give you 24 hours written notice to enter your property. Written notice there, again, doesn't necessarily mean that they're giving you 24 hours notice on a piece of paper. If you commonly speak with and get in contact with your landlord via text message or email, in the case of a notice to enter the property, it can be a text or an email when you acknowledge receipt. If you're moving out, they can give a 4 hours notice to come in to make to see the house and check on it. They can give their notice, and in the case of an emergency, they're able to enter the house without a notice period. So they suspect a fire, or there's water coming through the ceiling of the apartment under you, or something like that. They're able to enter the home, but generally landlords have to give you some kind of notice, get your permission. They can't just enter your home without asking, without you agreeing to it. Again, some exceptions there to protect persons and property are allowed, but hopefully nobody runs into a situation where that actually has to come up. Looking to end a lease. So this is when you're looking to end your lease in a way other than it terminating. If your lease is for a fixed period of time and it terminates and you don't want to be there anymore, that's fine. That can end your lease. That's the actual proper ending date for it. For a tenant, you want to let them know a month in advance when you're going to end it, and that way there won't be any more term. If you want to break it early, there are other periods. So as a tenant, you have to give at least 7-day notice before the end of the rental period to terminate an agreement. If it's week to week, it's 1 month on a month to month. And if it's a fixed term for 6 months or greater, you have to give them 2 months notice before the end of the rental period that you're leaving. Landlords have different obligations and their higher standards. A landlord can't evict you less than 4 weeks before the end of your rental period. That being, if your rental period is week to week, they have to give you kind of 4 months notice to move out. If it's a month to month rental agreement, they have to give you 3 months notice. So from the time that they tell you that you're evicted to the time you move out, the minimum amount of time that can be is 3 months. And same for a fixed term. So the minimum is 3 months. So if they tell you to leave, you don't have to leave for 3 months on a month to month or fixed term, or 4 weeks on a week to week. If you want to leave, you have are and you want to enter your notice that you're looking to leave the period on a week to week. You're responsible for at least a week of a rental period in that home. On a month to month, you'll be responsible for a month's rent, because the end of the rental period is there. And then on the fixed term, it's 2 months before the end of the rental period. So each of these are a little different, and depending on how the contract is drafted, can change when your minimum period is. So if you ever have any questions and you're unsure, you're thinking to yourself, well, I kind of want to leave this apartment, but I'm not sure if I have the proper notice period available, give us a call. That's what we're here for. Especially if you ever receive an eviction notice from your landlord, give us a call and we will definitely walk you through it and give you some options on how to deal with that and how to kind of seek a proper ending for yourself that works best for you. So again, if you do want to move out early, you can sublet. There has to be written consent from the landlord in most cases. A lot of the times, it'll be outlined in your rental agreement. This means that you become kind of a mini landlord, a landlord under the landlord who rents out that apartment or house to somebody else. So in turn, you then take on the responsibilities of a landlord once you sublet to somebody else, and you in essence become their landlord. An assignment is similar. Instead of you becoming a mini landlord, you hand over your rental agreement to somebody else. You tell, your friend who's coming to Newfoundland and Labrador, hey, I'm leaving early. Do you want to move into my place? You speak to the landlord, and the landlord agrees. They'll move the rental agreement over to somebody else. For termination notice with special circumstances, we talk about illness, admission to a nursing home, caring for an ill family member, death, or violence. Those are very extreme cases and all have much shorter termination notices. They're specific for each situation. So again, this is one of those things where if you're not sure, it's spelled out in the Landlord Tenancy Act, the Residential Tenancy Act. It's spelled out on the Government of Newfoundland and Labrador's website what the notice periods are for this. These are special circumstances that hopefully nobody here has to ever deal with, but should you, you can go to the Residential Tenancies Act. You can come to us if you have any questions. Other early terminations that are a little more common with cause can be the breach of a rental agreement by either the tenant or the landlord, non-payment of rent by the tenant, either the tenant or the landlord deem the premises to be uninhabitable. So the premises are no longer safe to live in. They're no longer meeting the required standards for people to live in. You can enter early eviction and early termination with cause then. And as well, you'll see this term quite often, an interference with peaceful enjoyment. Again, what that means is if a landlord walks into your house without 24 hours notice, if the landlord is playing music all night, if the landlord is stomping on the ceiling and you're in a basement apartment, those are things that aren't expected to be normal part of your living arrangement. Your peaceful enjoyment to your home, to be able to be there peacefully and not be disturbed. If there's a situation like that and you're looking to terminate early, again, give us a call, because some things are okay. Like your landlord upstairs is kind of a noisy guy and maybe wears his shoes inside. That's not something necessarily to do an early termination notice for. But like I said, if your landlord decides that every single night from 1 to 3 a.m. they're going to be tap dancing on the ceiling above you, then you might have a case for termination because of loss of peaceful enjoyment. If there's a dispute in the case of late rent, repairs not completed, the possibility of the apartment being abandoned, a failure to return a security deposit, an eviction, or any kind of disagreement between you and your landlord, you can either solve it together. We're definitely big advocates for speaking with your landlord and trying to come to some arrangement, some solution, some other option than taking it to a formal dispute resolution, because if you go to dispute resolution at that point, it's out of your hands. The determination is going to be made by somebody at the residential tenancies board, and it may not be one that you're comfortable with. If you can find an agreement that you're comfortable with between you and your landlord, we definitely recommend that, because that way, you're able to walk away at least somewhat involved in the decision making process, and have that, surety of an outcome. There's some risk of losing every time that you go to any appeals board and the residential tenancies board. So it's something to keep in mind, that if you can solve it between folks, we definitely recommend doing that. Landlords and tenants can try to solve it together, like we said, or either the landlord or the tenant can apply to the residential tenancy office slash board for assistance. There's an application for dispute resolution form. And what that is a form where you fill out your name and information, the landlord's name and information, what the issue is, and what resolution you're trying to seek from it. So in the case of, a failure to return a security deposit, you can enter a dispute resolution form to the board and say that your security deposit wasn't returned, and you would like an order from the board that returns your security deposit. They then will hear what the landlord has to say, and the landlord will have an opportunity to say whether or not they kept the security deposit or the damage deposit to repair the property, and they'll have to produce evidence of what was done there. You can also use mediation services, find third parties who will work with you. The residential tenancies officers will try to mediate the matter and go back and forth to make sure that that there's an actual mediation agreement to come out of it. So they'll help to try to resolve it without it becoming adversarial. If either person decides they're not going to abide by commitments that are in mediation agreements, the party can have it converted to an order. So a little bit of a difference here. A mediation agreement is kind of like a contract. It's legal, but it's not. There's no finding until it goes to the court, and there's an order made. An order is something actually enforceable through the courts. An order can be enforced by the RNC, the RCMP. It can be enforced through taking funds through bank accounts, and possessing belongings of either the landlord or the tenant to pay for the loss that may be there. So an order is kind of the formal be all end all. At that point, you have a very concrete measure that tells you that you have to do this, or else you could face legal consequences. And in Newfoundland and Labrador, most commonly what happens is, in the case of a breach of an order, a court will require you to pay it. But if your breaches, or the landlord's breaches, is so on its face bold and brazen, the court has the option to award jail time. Very extreme to ever see that happen. I think it's only been once or twice in the province that we've seen an order come with enforcement of jail time, and it was for landlords who had done particularly heinous things to their tenants. So don't fret about that. It's something that we very rarely see in the province, but it's something to keep in mind, that once something is an order, it moves from mediation into something solid and something that the parties have to comply with, or else there could be other legal problems that they'll have to deal with. Again, this is the final step, the adjudication process, where if nothing comes out of mediation, if nothing comes out of talking with your landlord, then you're going to have a judge essentially at the end of the day. They're not judges normal to the court, they're called adjudicators, and they're people appointed by the provincial government to the landlord tenant board for these hearings. They can either be phone hearings in person, in conference. There may be written submissions. But at the end of the day, the order that is made there is final, and it's a formal order that will be enforced by the courts. Again, this is very argumentative. It's what we see more like a court process where both parties are fighting for their own interests. There's no attempt to mediate the issue. Once it goes to adjudication, your only obligation is to prove your point. At that point, you and your landlord are directly opposed to each other, and so your job at that point, once you get to adjudication, is to make your case, let them make their case, and then the adjudicator will come back to you with a decision and the remedies that they're going to award. So the solutions that they're going to award. And again, it's not just money they can award. It may be a situation where they make an order that the landlord has to repair something. They make an order that the landlord's eviction was improper. And that's one that we see all the time, is that landlords will try to serve you with an eviction notice and tell you, you have to get out of my apartment in a month, even though you're on a month-to-month rental agreement, and the act says that you have 3 months notice to get out. I've seen it. We take calls on it pretty much all the time, of landlords deciding that they're above the law, and they'll tell you get out in a month. An adjudicator from the board can make decisions to invalidate that eviction notice. They can tell your landlord, no, you didn't properly evict someone. You now have to go. You have to serve proper notice on them, and it can reset the clock. And I've seen a lot of cases where an improper eviction notice was given to someone and they weren't prepared to move. They challenged the eviction notice, which, took 2 months for it to get to an adjudicator at the board. The adjudicator said, yep, that eviction was incorrect. You have to serve the proper one. And then they got another 3 months on top of the first 2 months to live in that apartment to find a new space in the city. So just because your landlord tells you have to get out, doesn't necessarily mean that you do. Again, if you have any questions and you think, my landlord's trying to kick me out illegally, give us a call. That's what we're here for. So we talked about this. Tenant may have to move out. There's questions on the validity of the notice. There may be questions about who has to pay what, and questions about on what conditions of the lease were violated, either by tenant or landlord. So the dispute resolution board is empowered to make a wide depth of decisions in terms of what kind of compensation they order for these breaches. So the adjudicators in a dispute resolution will listen to both people. They'll review the acts, the regulations. If you find any decisions from the board, they can also take those into consideration, and they'll take into consideration the written words of the lease as well. They might take into consideration things like text messages. If you come to an informal implied agreement on something in the house with your landlord, say that a common space, because somebody moved out, is going to be converted to strictly your space. That's something that you can rely upon, and those are kind of examples of implied terms that get upheld by the Residential Tenancies Board. If the decision is wrong and you think it's really wrong, you can appeal it to the Supreme Court of Newfoundland and Labrador. These are very difficult questions sometimes, because a board has a lot of power. And so you might think that the adjudicator that you had was wrong factually in some way, but for them to be incorrect factually, it has to be so on its face an error that it can't be ignored. They might, misstate something or might have heard something incorrectly, but so long as it doesn't completely overturn the case factually, it's a very high bar to reach. What's a little less difficult to overturn a decision on are questions of procedural fairness or law. So if you go to the board and they say, the termination period for a tenant is on a month-to-month agreement is 2 months, that is factually wrong at law and can be appealed. If they don't follow their rules and regulations for procedural fairness, and they do something like they don't give you an opportunity to submit any documents, they don't give you an opportunity to engage any way in the process, that can be appealed to the Supreme Court. if you get into a situation and it turns out that the dispute resolution person that you had was not impartial, if there's some way connected to your landlord and maybe making money some way on that, that's also something that you can appeal to the courts. So it's not to say that the dispute resolution is the be all end all. It's very commonly the final step for people, but there are opportunities to appeal those decisions to the Supreme Court. Those are going to be really kind of tough to parse out if you're not trained in law. And again, give us a call. We'll do a first look at it. We also offer a lawyer referral service where if we can't answer the question because it has to give you specific legal advice, we're able to connect you with lawyers across Newfoundland and Labrador who have agreed to a reduced flat rate of $40 to speak with them for a half hour, and they'll give you specific legal advice and tell you whether or not it's worth your time to appeal an order of the board to the Supreme Court. All right. If you have any questions, the landlord tenant board does have contact information there. You can call them, send them an email. They mostly answer questions about filling forms and procedural issues. How do you actually get before the board? How do you find a mediation? How do you get that side of things handled? So they're great for answering those procedural issues. If you've got more in-depth questions, let us know. Give us a call. Like I said, I went to law school. I practiced as a private lawyer. I take calls day in and day out on landlord tenancy issues, so we have a pretty good idea of the subject matter, and we can talk to you about the results and point you in the direction of what the law is, or point you in the direction of a form, or point you in the direction of an answer, or put you in touch with a lawyer. We can make sure that you find some answer to your questions. So here's my contact information. Write it down, take a screenshot. Just remember Public Legal Information Association. If you need to Google us later, that's my email. So if anyone has any questions, they'll go straight to me, and that's the phone number. I'm usually in the office from 9 to 4:30 and take calls throughout the day. You can also leave us a message, and we'll try to get back to you within 24 hours. All right. And you can find us online on Twitter and Facebook. You can find pictures of our summer camp. We had a bunch of kids, ages, I believe, 12 to 17, involved in a legal camp this summer. It was really cute. It was really nice to see bright young legal minds getting involved. And yeah. So, does anyone have any questions? Any thoughts, anything that's come up to you that you've just now thought after seeing this presentation might be an issue that you've faced before? Anything at all. I can answer any questions you folks might have right now.